Good afternoon, colleagues, and welcome back to this afternoon session of our short course on reading international trade agreements, reading and interpreting international trade agreements, a case study of the AfCFTA. As we indicated this morning, of course, we're going to focus our attention this afternoon on trade and services. And as we've discussed before, services have become increasingly important in all of our economies. In fact, for the continent as a whole, the services sectors constitute more than half of all economic activity. And of course, in some countries, a considerably larger contribution is made by the services sectors. What has also happened in recent years is, of course, that services, which generally used to be regarded by economists as non-tradable, have indeed become tradable. And they've become tradable as a result of changes in technology, reduction in costs associated with the use of technology. And that is particularly important because what we're doing this afternoon, colleagues, is exactly part of this broader trade and services agenda. We are sitting in South Africa. I'm in Cape Town. Professor Rasmus is in Stellenbosch, and you are located across the countries that constitute the Southern African Development Community, and we are able to commute and to conduct this training course. So without further ado, I'd like to say good afternoon to Professor Rasmus. Good afternoon.
Good afternoon, Judy, and everybody else.
And welcome, and a very warm welcome to all of you. So what we propose to do this afternoon is to take just a few minutes to take a look at some important issues related to the trade and services agenda. This is a more general discussion about how services are traded, services governance and trade governance issues. We've noted already this morning that services are regulatory intensive, and this has very specific implications, of course, for the nature of international trade in services instruments. And we will then, once we have done that, take a look at the Protocol on Trade and Services. We have, of course, also noted that trade and services is part of this agenda of ongoing negotiations, and aspects of the trade and services agenda will feature in the built-in agenda of the AfCFTA. So negotiations will continue into next year, and that's particularly important. We've also mentioned that other services sectors, which are not currently among the 5 priority services sectors, may be added to the agenda. And that would make sense because under the AfCFTA, the aim is to progressively liberalize trade in goods and trade in services. And that means adding to the list of services so that we do meet the requirement of Article 5 of the General Agreement on Trade and Services. So the General Agreement on Trade and Services, the multilateral governance instrument for trade and services. So without further ado, I would like to share with you just a few brief slides. And colleagues, I apologize not having shared this in advance. We will do that. And so I hope that our interpreters will bear with us as well. I will not go through all the slides in detail, but I will share them. And the trade and services agenda also has important linkages, for example, to the industrial development agenda related to aspects of the 4th industrial revolution. So at a future occasion, it may be a good idea for us to meet to discuss those issues in more detail. Without further ado, I think let's take a look at what services contribute to the 21st century economy. And this, colleagues, is just a reminder about industrial development and where we stand now in the 21st century. And what we do see, if we start with the 1st industrial revolution, that, of course, was when the steam engine was invented. and water power started driving the mechanization of production processes, very much in the textile industry initially. Then the second industrial revolution is where we start seeing mass production. And this is really where we start seeing sectors such as the automotive sector and the assembly lines associated with motor vehicle production, such as we've become familiar with in terms of the descriptions of what happened at the Ford Motor Company, for example, have become quite important. This is also where electricity enters the industrialization processes. So energy in the form of electricity becomes extremely important in making those conveyor belts move and for the production processes and the assembly lines to function very effectively. The third industrial revolution is really where we start to see the role of computers and automation. So this is already some time ago, colleagues, where automation becomes particularly important as far as repetitive tasks on assembly lines in motor vehicle assembly plants are concerned, and so on. But now we're in the fourth industrial revolution, and this is where we see a combination of extremely interesting developments from the third industrial revolution. So the picture testifies to that. So automation, robotics, cyber physical systems. But this is really where we start looking at nature, the biosphere, and learning from what happens in nature through developments such as biomimicry in the computer space. And this becomes then what we see as far as the industrial developments are concerned. So we see artificial intelligence. The very basic form of artificial intelligence is machine learning, becoming part of the way manufacturing is organized. We see automatic piloting in avionics, process control, and through artificial learning, we actually see developments being incorporated in our production processes in an evolutionary manner, so that production process to some extent become autonomous or independent from human intervention. And this is particularly important for us to keep in mind. This is where big data becomes very important, so that we can analyze masses of data associated, for example, with e-commerce transactions to track patterns of consumer behavior, patterns of consumer demand as they shift towards, for example, as far as food is concerned, to more plant-based food consumption and production, where you may find what looks like a steak being produced in a laboratory, for example. It's also where 3D printing and 4D printing becomes particularly important. We then encounter particular governance challenges. For example, if I receive the software to print a children's toy, for example, and I take it to a 3D printing operation, the question then arises, who is the producer? And in order to answer that question, we have to take a look at intellectual property rights issues. So it becomes really complex, because the very nature of innovation, of creative processes, of production processes, of distribution are changing very, very significantly. Very important development in the fourth industrial revolution, colleagues, relates to the sharing economy. And these are some of the developments such as Uber, Airbnb, and so on, where we now see users of services in the 20th century become suppliers of service. So I can rent out a room in my home. So I actually become a supplier of accommodation services, on a more regular and a more economic basis. Blockchain, or more broadly, digital ledger technologies. So these are systems for interoperability, sharing of data, become extremely important. Now, this kind of development is also very important in trade governance, because these are more advanced forms of what we're talking about when we take a look at single window systems for customs and border management. But digital ledger technology systems for trade management may, of course, cover a very large number of participants in, for example, a trade arrangement or agreement. It will involve also participation and access to the data by different agencies, the payments agencies, the standards authorities, customs and border management agencies, and even by the logistics suppliers and freight forwarders. Very important, all of these developments are related to trade in services. So trade in services becomes very, very important, not only in terms of services trade in itself, educational services, healthcare services, which can become e-education or e-healthcare services, but very important in relation to trade in goods. So the interconnections are really important for us to understand when we negotiate new trade agreements. And this is why, when we've emphasized at the beginning of this course how to read and interpret an international trade agreement, it is really important to look at the linkages and connections between different parts of the agreement, different instruments, as we have in the case of the AfCFTA. We have protocols, we have a number of different annexes under those protocols, but there may well be cross-references that we need to check very carefully for internal consistency, because keep in mind that an international trade agreement provides incentives to which producers, importers, exporters will respond, and according to which they will make trade decisions, and also decisions to produce goods and services. What we have also seen in the 21st century is the increase in the complexity of value chains. Now, this brings us back to some of the developments, for example, in SADC, and also in the AfCFTA, where we see reference to the development of regional value chains. And if we think about what a value chain actually is, it's simply a disaggregation of a production process across different geographies. So in the case of the automotive industry, for example, we may find Botswana produces the electrical systems for dashboards, Lesotho may produce the car seat covers, and the vehicle may be assembled in South Africa. But in the 21st century, these value chains become more complex and more sophisticated and more interconnected, also in terms of time, because we need to be able to assure that the requisite inputs are available when they are needed in the next step of the value chain. Otherwise, the value chain breaks down. So time and time at border posts takes on more significance the more complex our value chains are in the 21st century. And this again means that trade in services becomes really important. We also need to keep in mind that many products that you and I are consuming on a daily basis, many products we are consuming, very important, contain services. And this is what economists are calling mode 5. So for example, a motor vehicle will include a sound system or a tracking system or an alert system as to when you may need to service your car. This means there is software that is enabled in the motor vehicle to provide particular services associated with ordinary driving, as you and I used to know it. We've also mentioned that under COVID conditions, of course, the importance of healthcare and education have become very, very important. We talked briefly this morning, colleagues, about the links between trade in goods and trade in services. And extremely important, and when we talk about trade in goods agenda, in particular the trade facilitation agenda, trade facilitation is dependent on transport services, communication services, financial services, payment services, insurance services, and many, many other services. So when we look at the protocol on trade and services, we have to be cognizant of the fact that what is in that protocol and the annexes that go with it will have implications for our trade and goods agenda as well. I want to move very quickly to take a look at how services are traded. And this is important because we will find reference to these modes of supply of services in the protocol that we're going to consider in a few minutes. And the reason why this is important is that there are different ways in which services can be traded or supplied by the services supplier to the services user, whether the services user is another services company or a final user. So very important that we look at these very quickly. Mode 1 is cross-border supply. And this is where there is no movement of either the services supplier or the services user. It's exactly what we're doing this afternoon. I'm sitting in Cape Town supplying a service to you located in a number of SADC member states. This service is technology enabled. It requires foundational services such as energy, connectivity, but it also requires certain goods. It requires equipment. It requires a laptop or a smartphone or a tablet. It requires some kind of equipment to be the channel for that service to be supplied. It also requires other services in the form of software. So the Zoom platform that we're using is also a service. Mode 2, this is more traditional and well known to us. That's consumption abroad. And perhaps the best known to all of us is travel and tourism. But it could also be where students travel to a foreign country to study, to consume educational services, where a consultant travels from his or home territory to a foreign jurisdiction to supply professional services, whether it be architectural design or accounting services or a legal opinion. So this requires movement of persons. And this is, of course, the mode of supply that has been particularly hard hit during COVID as a result of the restrictions on travel and the movement of persons. So these sectors that we're talking about when we consider mode 2 will, of course, enjoy particular priority when we take a look at a strategy for post-COVID recovery, reconstruction, and development. The third mode, colleagues, is in terms of contribution to overall trade and services, the most important one. So in terms of value, the contribution of value to trade and services, commercial presence is the most important one. And this is effectively foreign direct investment. So this is where a services supplier, let's take a bank, establishes a commercial presence in a foreign jurisdiction with the purpose of supplying services to customers, which may be companies or final consumers like you and I, in that foreign jurisdiction. So earlier this year, there was great excitement in the financial services sector when Standard Bank, which is a South African-based bank, established a branch in Ethiopia. And why were we so excited about this? Because Ethiopia has been very closed to trade and services, and it has not opened its financial services sector to foreign participation. But what did happen at the beginning of the year was that Standard Bank was able to establish a branch to start supplying financial services to Ethiopian customers. This is also important, ladies and gentlemen, because it provides us with another important governance linkage that we should be aware of as we read the protocol a little bit later. And that is, if we have a foreign company establishing commercial presence in our territory, there are different modes of entry into the country. It could be a greenfield investment, so establishing a new company, an investor establishing an entirely new company to provide services, perhaps building a hotel or a bed and breakfast establishment, or it could be via a joint venture or a merger or acquisition. And from the mention of these words, we know immediately that here in the trade and services agenda, we have to be aware of the link to competition policy, which governs mergers and acquisitions as one of the areas of its governance package. The fourth mode of supply relates to the temporary presence of natural persons of one member state in another member state in order to supply a service. So this is where a consultant will travel to another country, but will require, for example, a work permit. So again, when we take a look at mode 4, we should note the following. It should not be confused with immigration. This is not about immigration, colleagues. It is a consultant, or it could be a teacher, an accountant, a lawyer who obtains a work permit to work and supply services in a foreign territory. So what we see is an interconnection here between trade and services and immigration law. So these governance connections are particularly important for us to keep in mind when we look at the Trade and Services Protocol. When we take a look at trade and services governance, we're not starting from a completely blank slate. And I think this is so important. So when our member states are negotiating the instruments under the AfCFTA, we have to be cognizant, take into account what exists already, what commitments have we made already. And most of our member states are actually parties to, or they're members of the World Trade Organization. And since in the World Trade Organization, all the legal instruments form a single undertaking, it means all of our member states that are members of the WTO are also parties to the General Agreement on Trade and Services. So that's commitments that we have all undertaken. In the case of SADC, there is a Trade and Services Protocol. There is ongoing work as far as that's concerned, adding new sectors, but also taking a look at frameworks for regulatory cooperation. Then, of course, there's the African Continental Free Trade Area, and we are currently preparing sector commitments for the 5 priority services sectors. There are also other negotiations ongoing where trade and services features prominently too. The SADC-EU Economic Partnership negotiations. Not all member states, but some of them are participating in discussions and even starting negotiations on trade and services with the European Union. The same is also true for the East and Southern Africa grouping of countries, which of course includes Zimbabwe, Madagascar, Mauritius, the island economies in the so-called ESA Economic Partnership Agreement. In the tripartite free trade area negotiations, keep in mind that's an initiative that started some years ago, being negotiated by the member states of SADC, East African Community, and COMESA. Trade and services negotiations, we understand, have begun already. So what we do see is that there are a number of tracks of work in progress on developing trade and services governance instruments. What we do have to look at and reflect upon is how many of our countries have actually developed a trade in services strategy policy. If we look at SADC member states, most of them have a trade policy, but the primary focus very often is on trade in goods. So some countries will have trade policy that talks about trade in goods, but does not yet incorporate trade in services. So this is something from an oversight perspective to be aware of. At some point, the executive will report upon trade policy developments, because of course, the Ministry of Trade is the focal point for trade policy making. And when they make briefings to Parliament, to the portfolio, to the select, the standing committees, they will report on policy developments. This is something we should look out for. Is there a trade in services strategy in our country? But very important also at a national level, and we mentioned this earlier this morning, are sector development strategies. So if we take a look at the educational services sector, healthcare sector, financial services sector, and many of the other sectors, many of our countries will have sector development strategies. And in fact, we may also find sector development strategies at the regional level and even at the continental level. So in the case of SADC, for example, there is a regional development strategy for the tourism sector, as just as one example. Coming back to the national level, because that really is an important focal point in this context and this conversation, it's important to keep in mind that these sector development priorities will have very important implications for the kind of policies and regulations that are developed by governments. So for example, in the communication sector, it is not unusual to find a policy objective of universal access, that government sets an objective that communication services should reach all citizens, not just those in the cities and the peri-urban areas, but that communication services are accessible to all citizens. Now, this may have important implications for regulations and market access that may be negotiated under a trade agreement. So important that we focus and we recognize that domestic regulation is particularly important for trade and services, and also for services sector development. We know services are regulatory intensive, there may well be cross-cutting regulations which impact all services sector. And some of these could relate, for example, to foreign direct investment, where a country may have domestic regulation related to foreign direct investment that requires that equity participation by foreign owners be limited to a certain percentage, say 25% or 49%. That would cut across all services sectors. But there will also be, of course, sector-specific regulations. So in the financial services sectors, of course, there are prudential regulations to protect the integrity of our financial institutions and to protect your and my savings in those financial institutions. But of course, we don't have similar regulations in communication or in healthcare or education. So sector-specific regulation is particularly important. This means that when we take a look at trade and services negotiations, we have new players to consider, and these are the sector regulators. So in most of our countries, for key sectors such as financial services, communication, energy services, transport, and so on, we will have sector regulators. And they are responsible for implementing the sector-specific regulations. But there may be occasions where sector regulators are required to interface and to cooperate with the more generic cross-cutting regulators. For example, the investment regulators, or for example, financial services regulators. And this then becomes extremely important for us to keep in mind when we take a look at how this interaction, how this interface will actually be managed. So sector regulation, extremely important, but there is also the matter of cross-cutting regulation that we have to keep in mind as far as the services sectors are concerned. A very brief word about the General Agreement on Trade and Services, colleagues. We will find reference in the General Agreement on Trade and Services to the modes of supply. We will also find, of course, reference to services classification. So what are services and how are they classified? Because although we have broad categories of services that are classified, there are many subsectors. So in the financial services sector, for example, there are subsectors such as insurance services, asset management services that are extremely important in the overall context of the financial services sector. In the communication sector, we usually find reference to, for example, telephony of different kinds, voice over IP, courier services would fall in some categories under the broad sector, for example, of transport services as well. So we have to look at quite a refined classification of services when we take a look at the sector commitments that member states will be undertaking in the AfCFTA. In the World Trade Organization, a very important recent development is the development of plurilateral negotiations and plurilateral working groups. And this reflects something that we have referred to earlier on in this discussion, and that is that since the establishment of the World Trade Organization, there has only been one new multilateral trade agreement that has been concluded, and that is the Trade Facilitation Agreement. But what has happened is that member states in smaller groupings have agreed to start work programs on a number of important issues. And these include e-commerce and also domestic regulation in services. And these two working groups are now actually making very good progress. Not all WTO members participate in these, obviously, at this stage, but can join and or accede to an agreement that may be concluded by a smaller grouping. Some countries, some members of the WTO, do not participate for various reasons. Some say they are not ready, they don't have adequate capacity, whereas others say we don't participate because this is not a multilateral initiative. So we will not participate in plurilateral negotiations. Be that as it may, it is very important to keep in mind that when it comes to trade and services, colleagues, that the General Agreement on Trade and Services was concluded at the time of the establishment of the World Trade Organization. That's the 1st of January 1995. You and I have experienced in the period since then significant changes in a number of services sectors. At the time the WTO was established, colleagues, I didn't have a cell phone. In fact, there may not even have been mobile phones. So the world has changed dramatically in the last 25, 26 years. And that has very important implications for trade and services governance. Has implications for the classification of services because new services have become available. But also new regulations and policies are required for these new services. So what we've started to see is that when it comes to free trade agreements, more innovative approaches to negotiating trade and services agreements have been developed. So one of the ones that we have a look at, and I'll only mention one of these, is what we used to call the Trans-Pacific Partnership. It's now known as the Comprehensive and Progressive Agreement for Trans-Pacific Partnerships. In this agreement, Trans-Pacific Partnership agreement, from which, of course, President Trump withdrew as soon as he came to office, includes a number of chapters that deal specifically with different services sectors. So it includes a chapter on financial services, a chapter on e-commerce, for example. So instead of having a separate protocol on trade and services as we see in the AfCFTA, this agreement is structured as a list of different chapters dealing with substantive trade issues. And as far as trade and services is concerned, dealing with different sectors where member states express in the preamble to that chapter very important development ambition. They commit to services sector development priorities, and then take a look at commitments in terms of whether it be regulatory cooperation or harmonization, which is increasingly important when it comes to trade and services. So that's a more modern way of structuring a trade and services agreement. The way we have structured the African Continental Free Trade Area follows very much what we would have seen in the early 1990s in terms of free trade agreement configurations, where we have protocols and a rather comprehensive approach for undertaking services commitments, rather than focusing, as the Trans-Pacific Partnership Agreement does, on very specific sectors, sector priorities, and including these in very specific dedicated chapters. This is just a little bit of detail about the initiative in the World Trade Organization, the Plurilateral Initiative on Domestic Regulation in Services. And this comes from the ministerial conference of the WTO that was held in Buenos Aires and that was 2017. And 59 members of the WTO issued a joint statement committing to advance negotiations on domestic regulation and to seek agreement by the next ministerial conference. Now, of course, that did not happen because we were supposed to meet, and then COVID struck. So we are looking perhaps to have the next ministerial conference next year, 2021. At this stage, and of course, things do change sometimes quite rapidly as far as these initiatives are concerned, Nigeria is one of the African countries participating. At the time I had a look at the list a couple of weeks ago, there was no other African country participating, but we do need to have a look at how that could change. I think at this stage, I want very, very briefly just to look at the objectives of the General Agreement on Trade and Services, because what we'll find in the Protocol on Trade and Services is very similar. One of the objectives is to expand trade and services through progressive liberalization. This is terminology, colleagues, that we see both for trade in goods and trade and services negotiations in the AfCFTA. Emphasis on transparency, very important here. Let's have a look and see if we find that in the context of the AfCFTA Protocol on Trade and Services. One of the objectives was also in the GATS to have more participation by developing countries. Now, what we have to keep in mind in the AfCFTA is there is enormous diversity. We have some large, more developed economies, South Africa, Egypt, Kenya, but then we also have a very large number of least developed countries participating in the negotiations. So it's a matter of finding common ground, finding the necessary concessions and agreement among unequal partners on some very, very technical issues. I want to very briefly just have a look, and I will share this, colleagues. This is just about the classification of services, which we'll have a look at in detail. But I want us just to have a quick look at the practical ways in which we make our commitments. And we have an example here for Botswana. And this table is basically what the schedules of commitments will actually look like. So let's take a look at communication services. So this is the broad category of services, or travel and tourism. This is perhaps a better one to have a look at. And within this broad category of services, we will have certain subsectors. So within travel and tourism related services, one of the subcategories is the hotel and restaurant, including catering services. Another very important subsector is travel agencies and tour operators. Now, what we'll see in these two columns, colleagues, is reference here to market access, and next to that, reference to national treatment. So essentially what we aim to do is to provide concessions in terms of market access and national treatment. So to open our markets, grant market access, and then to grant national treatment to foreign services and foreign services suppliers. Now, how the General Agreement on Trade and Services works, and this is exactly what we're following in the African Continental Free Trade Area negotiations, is that in these columns, we say we will grant market access, but subject to limitations. We will grant national treatment to foreign services and foreign services suppliers, but we will have limitations on that national treatment that we will grant. So the logic is a little bit of a reverse logic that we adopt. We say we will grant market access, but we register certain limitations. Now, these numbers that you see, 1, 2, 3, 4, refer to the modes of supply. So let's have a look at one example. So when it comes to travel agencies and tour operators, Botswana says we will grant market access to foreign services suppliers. So foreigners may establish tour agencies, travel agencies. But what are the limitations that Botswana has registered? So for cross-border supply, so this could be electronic booking via email, for example. There's none. What does that mean? And this is the code. If none is registered, then we have no limitations. So foreigners are free to supply services via mode 1. So that's via the internet with no restrictions. When we take a look at mode 4, ladies and gentlemen, this, remember, involves the presence of natural persons. Then, unbound is the term used. Unbound means that Botswana is not permitting natural persons to come and supply these services, except as indicated in the horizontal commitments. The horizontal commitments are those that apply to all services. So this is quite important to keep in mind. Let's have a look at one more example because this is rather complicated. If we take a look at national treatment, and let's have a look at travel agencies and tour operators. So this is mode 1, cross-border supply. Permanent residents should not purchase tickets to enable non-residents to visit Botswana and accept payment outside Botswana. Now that's an interesting one, because most likely in Botswana, there are different prices for Botswana nationals or permanent residents, and for foreign tourists, foreign visitors. So we don't want a situation where permanent residents are able to, in a sense, undercut the development regulations that have been promulgated for the development of the tourism sector. If we take a look at number 2 here, so this consumption abroad, there are no limitations, but this is a rather obvious one because, ladies and gentlemen, when it comes to these services, what we find more and more now is that the booking systems and so on for travel and tourism, airline tickets and so on, can of course be done online. So this is a sector which has experienced quite a lot of change as a result of technological developments. I would like just to go back to one example that is quite important. And this is where we see the horizontal commitments that Botswana has undertaken. And I want to focus your attention just in the limitations on national treatment. The second last point here, the Ministry of Commerce and Industry should be notified of all sale of business interests, mergers and takeovers. So this relates to sale of business interests, mergers and takeovers. Now that usually is the governance territory of the competition authority. But in 1995, when Botswana registered this schedule of specific commitments, it did not have a competition authority. So the Ministry of Commerce and Industry had to be notified since it was playing that governance and regulatory role. But this schedule should be updated to reflect the reality that Botswana, of course, now has a fully functional, a very competent competition authority. So my point really, colleagues, is that these schedules have to be a living document because, of course, over time, what we will see is that new regulations will be introduced to promote new sector development priorities or respond to new technological developments, innovation, or market developments. Ladies and gentlemen, that's all I want to say about trade and services. I know it sounds probably quite a mouthful, but what I would like to do is now for us to go to the protocol on trade and services, because we're going to pick up on some of these technical issues, and then we should get clarity on some of the issues. Does anyone have any questions so far while I simply go back to the agreement and to the protocol on trade in services? Any questions or any comments, colleagues? To some extent, and I have to agree here, that trade and services governance is more complex technically than trade and goods. I think we've been working with the trade and goods agenda for so long that we are all quite conversant with tariffs and other border measures, customs and border management issues. But when it comes to trade and services, some of these sectors are developing so fast that it becomes quite difficult to keep up with some of the technological and also the regulatory issues that are adopted to effectively govern developments of those sectors. Professor Rasmus, any comments from you?
No, I sit here spellbound, Trudy.
Right, let's have a look, colleagues, at the protocol on trade and services. As always, there is a preamble. And keep in mind, we, members of the member states of the African Union, determined to establish a continental framework of principles and rules for trade and services with a view to boosting intra-Africa trade in line with the objectives of the AfCFTA and promoting economic growth and development. So the link between economic growth and development and the trade and services agenda is recognized. I want to take a look at this one here, desiring to harness the potential and capacities of African services suppliers, in particular at the micro, small, and medium levels, to engage in regional and global value chains. So we have here a link to industrial development. This is particularly important. The next point here, recognizing the right of states to regulate. This is a central focus and concern on the part of member states in the trade and services negotiations. They do not want their right to regulate to be compromised as a result of the commitments they undertake. And to some extent, of course, once commitments are undertaken, then to some extent policy space is compromised, but the right to regulate when it comes to trade and services is emphasized very, very strongly. I want to emphasize and underscore that. The second last point, acknowledging the African Union Assembly decision adopted at the 30th Ordinary Session of the Assembly of Heads of State and Government of the AU on the 28th of January 2018. Keep in mind, colleagues, this is 2 months before the extraordinary summit at which the AfCFTA agreement was tabled for adoption and signature. So in January, just before that, we have a very, very important decision. This is the establishment of a single air transport market through the implementation of the Yamoussoukro decision. So a decision about a single air transport market was taken prior to the adoption and the tabling for signature of the AfCFTA. This is quite important to note when we look at the coverage of the Protocol on Trade and Services and what aspects of air services are covered and which are excluded because they are already covered in a separate legal instrument, the Yamoussoukro decision. Let's move ahead. So the AU member states have agreed as follows, and here we have the definitions clause. And it is notable that commercial presence is the first definition that we encounter. As I mentioned earlier, the establishment of commercial presence, which is foreign direct investment, is the most important channel for trade and services. And so this needs clarity. What exactly does establishment of commercial presence mean? It means any type of business or professional establishment. So this could be a law firm, including through the constitution, acquisition, or maintenance of a juridical person, or the creation or maintenance of a branch or a representative office within the territory of a state party for the purpose of supplying a service. So, a number of important issues to note. In Roman 1, the constitution, acquisition or maintenance of a juridical person. So this relates to matters which again require us to cross-reference with the Protocol on Competition Policy, because we see it refers here, for example, to acquisition. So business acquisition, that is subject to competition regulation. Reference to taxes, very, very important, of course. And increasingly we have debates and discussions about taxation related to digital transactions, for example. Professor Erasmus, do you want to say anything about juridical person?
Yeah, we all know, ladies and gentlemen, that if a constitution or a law speaks of persons, our first association there with is that it is a natural person. You and I are natural persons. A juridical person means any legal entity duly constituted or otherwise organized under applicable law of state parties, and whether privately owned or owned by government, including any corporation, trust, partnership, joint ventures, sole proprietorship, or association. The typical manifestation of a juridical person is a company. And here we have a list of examples. So on the one hand, we have natural persons, on the other hand, we have juridical persons. And it is important that we cover both of them in these types of agreements, in particular in when it comes to trade and services, because the commercial reality, the business world, is organized on the basis of legal persons, we sometimes call it, or juridical persons, that will be the same, being established for the purposes of providing those services, owning them, and allowing for other types of commercial activities like shareholders, equity, and so on to be accommodated. So we all know what a company is. Some of you may be shareholders in companies, but a company is a typical legal person, a typical juridical person. And where do they come from? How are they born? We know how a natural person is born. How is a juridical person born? And here we see the answer. Constituted or otherwise organized under the applicable law of the state party. How is a company established? How does a company come into existence in your country? It must be established, it must be incorporated under the Companies Act. So it requires a legal procedure and an application for registering a company. And if you take all these principles together, you can see and understand why in the provision of services, juridical persons come in many forms and formats, but it is central to the control over service providers, and in particular in mode 3, that we know what we are talking about when juridical persons are mentioned. I hope that suffices, Trudy.
Thanks very much, Professor Erasmus. That is really important because, of course, foreign direct investment may take different forms, and very important that we take a look at the different arrangements, constitutions, if you like, or modalities of foreign direct investment for the establishment of a commercial presence. Again, I just want to emphasize that in this connection, we are seeing a very important link between the trade and services agenda and the competition policy agenda. So what happens in the second phase of the negotiations will be very, very important to cross-reference back to the protocol on trade and services. I want to come to F here, where measure is defined. And a measure means any measure that sounds rather tautologous by a state party, whether in the form of a law, a regulation, a rule, procedure, decision, administrative action, or any other form. So this is really a very broad coverage of interventions by government, which may take different formats. Regulations probably in the field of services is quite common, but it could also be an administrative action or a decision or a particular procedure, which could be relevant in the trade and services governance context. So quite important to keep that in mind. If we look very quickly at H, monopoly supplier of a service is defined. And colleagues, this is very important because there are a number of services sectors where historically and even today, we still find monopolies, a single supplier of a particular service. Historically, many of those monopoly service suppliers were linked to the state, either directly owned as a state-owned enterprise or partly owned. And what we have seen, particularly in the communication services sector, as new services have entered the market. So for example, mobile phone services. In the case of South Africa, we initially had two mobile services suppliers, MTN and Vodacom. And if we take a look at ownership of these two, then government played a role in certain of these private sector players. So a private mobile company was part owned by government. And so quite important to keep in mind that there are market developments which are prompted by innovation in many of these services sectors. So as a result of changes in terms of how the markets function, the kind of services that they offer, and these technological developments that are becoming more and more commonplace in a range of services sectors, we have to take a look at who are the productive players in those services sectors. And we still have in services such as communication, transport, energy, and in some cases, some countries, even in financial services, government playing a very important role. So we need to understand how these markets work and who are the services suppliers. Natural person, I think we would know what that means. It is fairly intuitive. Sector of a service means with reference to a specific commitment, one or more or all subsectors of that service. So as we saw with travel and tourism services, it could be hotel and restaurant subsector, or it could be travel agencies, for example. Financial services, as I mentioned, it could be insurance services. And of course, within insurance, the insurances services subsector, we have a lot of further subsectors. It could be travel insurance. It could be reinsurance, for example. So we need to take a look at the definitions of the particular services quite carefully. Transport, the transport services sector is a very interesting one because there again we have a lot of subsectors. So we've got road, rail, maritime transport, and each of those subsectors will have its own set of specific regulations. Services consumer, this could be a person, you or I, or a juridical person. It could be another company that buys communication services from a telecom services provider. Supply of a service includes production, distribution, marketing, sale, and delivery of the service. So it is the entire value chain of that service which is included. Trade in service, very specific definition here, means the supply of service from the territory of one state party into the territory of another state party. In the territory of one state party to the service consumer of another state party. So if we take a look at the different modalities for the supply of trade and services, I think that's quite important. Scope of application, very, very quickly. The protocol applies to measures by state parties affecting trade in services. So this applies to that collection of measures that we had a look at in the definitions clause. For the purposes of this protocol, trade in services is based on the 4 modes of supply. They are defined a little bit later, but those are the ones we had a look at earlier today. So it is cross-border supply, consumption abroad, commercial presence, and temporary presence of natural persons. Those are the 4 modes of supply. We'll have a look at them a little bit later here. Measures by state parties. Here we take a look at further elaboration of what that actually means. It's state parties, central, regional, or local governments and authorities. In other words, it is not just measures implemented by national government, by regional, local government, and authorities. So it could be the local municipality that introduces a particular regulation about the supply of a specific service. That would be covered as well. non-governmental bodies in the exercise of powers delegated by state parties, central, regional, or local governments or authorities. So this again broadens the scope of where these measures could come from. Services, and let's look at B. Services include any service in any sector except services supplied in the exercise of governmental authority. So this would be the firefighters or educational services provided in government schools, for example. So this quite important to keep in mind. So any service except those supplied in the exercise of governmental authority. A service supplied in the exercise of governmental authority is further clarified to mean any service which is supplied neither on a commercial basis nor in competition with one or more services suppliers. So that is important to keep in mind. The protocol does not apply, shall not apply to measures affecting air traffic rights, however granted. That would be subject to, remember we looked at the Yamoussoukro decision reference right at the beginning. Services directly related to the exercise of air traffic, but the protocol does apply to measures affecting aircraft repair and maintenance services, the selling and marketing of air transport service, and very importantly for the tourism sector, the computer reservation services. So that is covered. Objectives, and these are cast quite broadly. We don't have to look at all of them in detail, but it starts off with, very importantly, the principal objective of this protocol is to support the objectives of the AfCFTA. So that's the objectives in the umbrella agreement. Specific objectives of this protocol: enhance competitiveness of services through economies of scale, reduce business costs, enhance continental market access, and an improved allocation of resources, including the development of trade-related infrastructure. So quite important, very broad, but still quite specific objectives. Promote sustainable development in accordance with the SDGs, foster domestic and foreign investment, accelerate industrial development and regional value chain development, progressively liberalize. So this term progressively, we also came across in connection with liberalization of trade and goods. So again, it's not a big bang approach. We will progressively liberalize trade and services on the basis of equity, balance, and mutual benefit by eliminating barriers to trade and services. This is quite important if ensure consistency and complementarity between the liberalization of trade and services and the various annexes in specific services sectors. Now, this is quite important because this still is work to be done. G, pursue services trade liberalization in line with Article 5 of the GATT. That's very important. We're referencing our commitments in the WTO. By expanding the depth and scope of liberalization and increasing, improving, and developing the export of services while fully preserving the right to regulate and to introduce new regulations. Let's move very quickly. We're running out of time very fast. General obligations and disciplines in part 5. We have the counterpart to the most favored nation treatment provisions that we saw under the Protocol of Trade in Goods. So I won't go through that in much detail. And then we should also expect to see some other counterparts to what we have in the Trade in Goods Protocol. Notable here is reference to transparency. And ladies and gentlemen, this becomes so important when we recognize the regulatory intensity of trade and services, because transparency pertaining to regulation is absolutely critical. Not only the regulations per se, but the administration, the implementation, application of those regulations needs to be transparent. This is about due process, about administrative justice. So very important that there is quite extensive article related to transparency. And let's just have a quick look at a couple of the provisions here. Each state party shall notify the Secretariat of any international or regional agreements pertaining to or affecting trade and services with third parties to which they are signatory prior to or after entry into force of this protocol. So a notification requirement. Each state party shall promptly and at least annually notify the Secretariat of the introduction of any new or any changes to existing laws, regulations, or administrative guidelines which significantly, and that's notable, which significantly affect trade and services under the state protocol. Where a party submits a notification to the Secretariat, the latter, the Secretariat, shall promptly circulate to all the state parties. So this is a very important role for the Secretariat. And again, from a parliamentary oversight perspective, this is something to watch out for. At least annually, a notification must be made to the AfCFTA Secretariat about the regulations, the guidelines, the administrative guidelines, all the measures that have been adopted. Article 6, disclosure of confidential information. Nothing in this protocol shall require any state party to disclose confidential information. So this is extremely important to keep in mind. So access to information, protection of information is really important. Let's just read the whole article. Nothing in this protocol shall require any state party to disclose confidential information and data, the disclosure of which would impede law enforcement or otherwise be contrary to the public interest, or which would prejudice legitimate commercial interests of particular enterprises, public or private. Special and differential treatment, and this is very important to keep in mind. As we mentioned, we are integrating unequal partners. And in the case of some of the state parties of the AfCFTA, we may find that they do not yet have sector regulators for all the services sectors, and that some of their services sector developments may be lagging behind that of others. So very important that special and differential treatment is provided for. Note the last point here, C. State parties shall accord special consideration to the provision of technical assistance and capacity building through continental support programs. This is really important. The role of capacity building is recognized explicitly as may be required by some of the state parties. The right to regulate. This, colleagues, we've seen this point emphasized a number of times now. Each state party may regulate and introduce new regulations on services and services suppliers within its territory in order to meet national policy objectives, insofar as such regulations do not impair the rights and obligations arising under this protocol. So the right to regulate is linked to national policy objectives, sector development objectives, extremely important. So this is policy space, so to speak. The right to regulate is safeguarded under certain conditions, insofar as the regulations do not impair any rights and obligations under this protocol. Domestic regulation in sectors where specific commitments are undertaken, so that's what our member states are busy with right now. Each state party shall ensure that all measures of general application affecting trade and services are administered in a reasonable, objective, transparent, and impartial manner. This is administrative justice, due process. So very important. In order to achieve that, each state party shall maintain or institute as soon as practicable judicial, arbitral, or administrative tribunals or procedures which provide at the request of an affected services supplier for the prompt review of, and where justified, appropriate remedies for administrative decisions affecting trade and services. Where such procedures are not independent of the agency entrusted with the administrative decision concerned, the state party shall ensure that the procedures, in fact, provide for an objective and impartial review. I want very briefly in our last few minutes, colleagues, to focus on Article 10. Mutual recognition is particularly important in the cross-border supply of services. Let's read these paragraphs together. For the purposes of the fulfillment in whole or in part of its standards or criteria for the authorization, licensing, or certification of services suppliers, and subject to the requirements of paragraph 3 of this article, which we'll have a look at, a state party may recognize the education or experience obtained, requirements met, or licenses or certifications granted in another state party. Such recognition, which may be achieved through harmonization or otherwise, may be based upon an agreement or arrangement with the state party concerned, or may be accorded autonomously. Colleagues, this is very, very important. If we think about professional services, it could be engineering services, accounting services, legal services, medical services, and so on. What mutual recognition refers to is the recognition of the education and or experience obtained, the licenses, the permits or certifications granted for the supply of a particular service in a state party. If we have mutual recognition, it means that the qualifications and or the experience and all the above may be recognized by another state party, so that this services supplier will be able to legitimately supply said services in that foreign jurisdiction. Now, this is an extremely important issue because, of course, different professional services may require different considerations when it comes to mutual recognition. If we think of accounting services, for example, there are international benchmarks, guidelines on training and of good governance principles, and so on. The general accounting practices, the GARP, IFRS, there are international benchmarks and standards for this type of education and qualification. However, the qualification of in other services sectors may actually be to some extent specific to a particular legal regime, for example. And therefore, each of these mutual recognition agreements will be considered individually and very, very carefully. And in some cases, mutual recognition may be contingent upon, for example, the services provider writing an additional exam, or obtaining some kind of additional certification in order to supply services in a foreign jurisdiction. But this is extremely important. And we have some very interesting experience from the East African community. East African community adopted a common market protocol in 2010, and they started implementing this protocol, which permitted the movement of services suppliers among the member states, but then came up against the challenge of mutual recognition of qualifications obtained, for example, in Kenya, which were not recognized in Tanzania, for example, by the relevant professional bodies, for example, the accountants professional body or the law society, for example. And so they have had to go back to the drawing board and to negotiate mutual recognition agreements for the supply of particular professional services. So some headway has been made in areas such as accounting services, which is perhaps one of the easier ones to negotiate mutual recognition about. But this is absolutely important. It's important for you and I as users of those services, but also from a broad governance perspective. We want to be assured that if we are going to be using the services of a professional services supplier from another jurisdiction, that services supplier is competent, is qualified, has the appropriate education, qualifications, and experience to provide the particular service. So this is extremely important to keep in mind. So there are quite a number of very important aspects to brokering mutual recognition agreements. And we'd have to look at those quite carefully. Article 11 talks about monopolies and exclusive services suppliers. We won't go through that in detail, but it's a clear reference to competition policy issues. And we will find provisions in the protocol on competition policy which address these issues as well. We have to cross-reference. So very important to keep in mind. Similarly, Article 12 speaks to anti-competitive business practices. Now, this is the equivalent of unfair trade practices in trade in goods. So we're now looking at anti-competitive business practices, which of course can erode the benefits of services liberalization and market integration. Again, extremely important because this is the fabric of competition governance. So we'd have to look at that very carefully. Payments and transfers. This article is an important one because, of course, if we have cross-border supply of services, we will need to have cross-border payments and transfers. And here, if we read very carefully, it says, except under the circumstances envisaged in Article 14, so that's the one to follow, a state party shall not apply restrictions on international transfers and payments for current transactions relating to their specific commitments. In other words, payments and transfers, cross-border payments and transfers are essential, as we would expect. We have reference to the International Monetary Fund and the rights and obligations of members. Of course, we are all in that boat. And this has become particularly important now during COVID, where we have turned to international financial institutions such as the International Monetary Fund. Restrictions to safeguard the balance of payments. We saw that in the Trade and Goods Protocol as well, so a counterpart to that. So we should read through to assure internal consistency in those provisions. Article 15, here's the general exceptions clause. Subject to the requirement that such measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between state parties where like conditions prevail. or a disguised restriction on trade and services. Nothing in this protocol shall be construed to prevent the adoption or enforcement by any state party of measures necessary to protect public morals or to maintain public order, necessary to protect human, animal, plant health, necessary to secure compliance with laws or regulations which are not inconsistent with the provisions of this protocol, including those related to the prevention of deceptive and fraudulent practices, or to deal with the effects of default on services contracts. Deceptive or fraudulent practices, this could be by services providers who may not be duly qualified to provide those services. And here, very important, Roman 2, the protection of the privacy of individuals in relation to the processing and dissemination of personal data, the protection of confidentiality of individual records and accounts. Colleagues, this issue about the protection of privacy, personal data, will be very important also, of course, in the protocol on e-commerce. So let's keep that in mind. We will find reference to that as well. Security exceptions, and Professor Rasmus, this is again the counterpart to what we have seen in trade and goods, but pertaining now to trade and services. Article 17 on subsidies. Nothing in this protocol shall be construed to prevent state parties from using subsidies in relation to their development programs. So this is particularly important, the use of subsidies permissible. Keep in mind, ladies and gentlemen, that in the World Trade Organization, there is an agreement on subsidies and countervailing measures. So there is, in a sense, a multilateral reference that we have to consider when we read this article on subsidies. Progressive liberalization, part 5, very similar to what we find for trade in goods. Market access, so this is that brief example we had a look in, a small window into what sector commitments could look like. Market access, we open our markets subject to certain terms, limitations, and conditions agreed in a specific schedule. So in our yes, Professor Rasmus.
Can I ask you something? If you can please go back to Article 18, paragraph 2. Can you just go through the body of that provision?
Sure. State parties shall negotiate sector-specific obligations through the development of regulatory frameworks for each of the sectors as necessary, taking account of the best practices and acquis from the regs, as well as the negotiated agreement on sectors for regulatory cooperation. State parties agree that negotiations for continuing the process shall commence following the establishment of the AfCFTA based on the work program to be agreed by the Committee on Trade and Services.
So that there are a number of elements in here that are very important, but the reference there to the negotiated agreement on sectors for regulatory cooperation, what does that mean?
Apologies. If we take a look at the structure of the governance instruments for trade and services, we have a protocol, then we have sector commitments for, at this stage, the 5 priority services sectors, and then we have provision for frameworks for regulatory cooperation. So these are part of a collection of different governance streams for trade and services under the AfCFTA. So if we look here, state parties shall negotiate sector-specific commitments. So this would be written up in the schedule similar to the example we had a look at for Botswana, through the development of regulatory frameworks for each of the services sectors as necessary, taking account of best practices and the acquis from the regs. SADC is busy with this process at the moment. SADC has identified 6 priority services sectors. Some of them coincide with the AfCFTA, but of course not entirely, because, for example, in SADC, energy-related services is a priority services sector, whereas under the AfCFTA, that's not the case. The recognition here is that for each of the services sector, the regulatory frameworks are different. There are cross-cutting issues, which we see in the horizontal commitments. So they would relate, for example, predominantly to mode 3, which is foreign direct investment, and 4, which is the temporary presence of natural persons to supply services. But to the extent, of course, that our services sectors are very different, the regulatory frameworks are very different. So the specific obligations would have to reference that particular regulatory framework. When we take a look at the frameworks for regulatory cooperation that are to be concluded, this is really to start taking a look at the process of perhaps eventually moving to mutual recognition of regulation, and finally to harmonization of regulation across services sectors in the state parties. But we have to keep in mind that regulation and the reference to regulation is also important with respect to the right to regulate. So on the one hand, we would like to move to regulatory frameworks for each of the sectors and regulatory cooperation, the term at this stage used in the context of the AfCFTA is cooperation, not harmonization. But at the same time, the right to regulate, to develop domestic services sectors is also recognized. So a bit of a tension between these two. But there is reference to best practice and the acquis of what already exists. Now, as far as the regs are concerned, EAC is probably the most advanced in this area of governance, trade and services governance. There is still a lot of work that needs to be done, for example, in SADC. So the acquis is in the making, so to speak. And of course, that process will continue.
Thank you very much, Trudy.
A great pleasure.
We will probably have to stop here and do the rest tomorrow.
We can do that. Ladies and gentlemen, thank you so much for joining us this afternoon. And these are extremely technical issues, but it's useful for us to think about the services that you and I consume. Communication services. Think back to the mid-90s, what communication looked like. We all had landlines. Now many of us don't. We rely on voice over IP, mobile phones, smartphones, and so on. So the nature of so many of the services sectors has changed very, very dramatically. And that means we need new policies, new regulations. And this has implications for what we do in a trade and services agreement, such as the AfCFTA. But keeping in mind that there are processes underway at the REC level as well, and also at the WTO level. So thank you so much, colleagues. We'll join you again tomorrow morning at 10 o'clock. Thank you so much, Professor Erasmus. Have a very good afternoon. And if you have any questions overnight, do send them to us and we'd be happy to answer them tomorrow. Thank you so much for joining us.
Thank you, Trudy. Thanks, everybody. See you tomorrow morning at 10 promptly.
Thank you.
Bye.